Good day to you and welcome to another video tutorial. We are currently awaiting news of the promulgation of the Sectional Title Scheme Management and Community Scheme Ombud Service Acts, which we expect very shortly. For those of you who have not yet focused on this area, I'm now going to give you a brief overview of the role of this Ombud service in the operation of sectional title schemes. I've characterized it firstly under the heading Keeper of Documents. Every sectional title scheme's rules, not only the original management and conduct rules lodged by the developer when the sectional plan was registered, but also all later amendments will be held by the service. And all future new rules, whether for new schemes or changes to the rules of existing schemes, will first have to be approved by the service. The service will in addition keep the Form W, that certificate of establishment of the body corporate. It will be the place that you lodge the notice of any service address changes, what we call the domicilium citandi et executandi. And of course, it will keep copies of annual returns and all the documents that are required to be lodged with the annual return to the Community Scheme Ombud Service. Any administrator who is appointed at the moment by the High Court to lodge with the Ombud the copies of all notices and minutes of meetings and all written reports on his or her administration of the scheme, which will have to come in every 3 months at least. There may also be other paperwork which is kept by the service, but it's unlikely that they will, for example, keep copies of plans and the sorts of things that you will find in the deeds registry or in the Surveyor General's office. The second main heading is that they are the recipient of community scheme levies and, of course, the annual returns that I mentioned. That is vitally important. Every scheme is now going to have to budget for levies, and that's going to be a major change. The service is, in the third instance, the mediator and adjudicator of disputes. And as you probably know, there's a very wide range of disputes under 6 headings in the Community Scheme Ombud Service Act. It has the following categories: financial matters, behavioural and scheme governance issues, meetings, management services, works pertaining to private and common areas, and general and other issues. So it's really very, very wide. Any form of real dispute that arises within a sectional title scheme and cannot be resolved by internal mechanisms will be able to be referred to the service, and there will be initially an attempt to mediate or conciliate the matter, and if that doesn't work, then there'll be an adjudication. Levy recoveries are perhaps one of the most important elements of this dispute. They're not always disputes, sometimes it's just people can't pay, but the feature is that a body corporate may and must recover all contributions, whether they're special or ordinary levies, from owners by way of an application to the Ombud instead of having to use a court process. Now, the need for the service in regard to disputes generally has already been proved by the volume of applications that this nascent organisation has received in the last 6 to 8 months, even before the acts are operational. Once its jurisdiction to hear claims is in place and it can move from mediation or conciliation to adjudication of disputes, I expect that it will be inundated with applications. We will keep you informed of progress as it occurs, and thank you for joining me in this video.